Hello students, welcome to SRIRAM's IAS UPSC Prep channel. Welcome to this detailed analysis of Indian Polity. Indian Polity 2025 का मेंस का क्वेश्चन पेपर. There were 9 questions which were asked from Indian Polity. एक एक करके इन क्वेश्चन को देखेंगे, नेचर ऑफ क्वेश्चन को देखेंगे, क्या डिमांड थी उसको देखेंगे और उसको आंसर करेंगे. सो लेट्स स्टार्ट आवर डिस्कशन. पहला क्वेश्चन, और याद रखिएगा एक एक जो क्वेश्चन है, the numbering of the question has been done exactly how you must have found it in the real paper. Now, the first question, paper number 2 of Indian Polity, which was asked was this one. Discuss the corrupt practices. आप इस क्वेश्चन को देखिए बहुत ध्यान से. अगर आप इसको पढ़ेंगे you will be able to answer it. कुछ चीज़ें हैं जो आपको पता होनी चाहिए, कुछ चीज़ें रिप्रेजेंटेशंस ऑफ पीपल एक्ट की हैं जो आपको पता होना चाहिए. करप्ट प्रैक्टिसेस क्या होती है, करप्ट प्रैक्टिसेस के अंदर क्या क्या आता है, अनड्यू इन्फ्लुएंस का मतलब क्या होता है, डिस्प्रपोर्शनेट इनकम का मतलब क्या होता है. ये कुछ बेसिक चीज़ें हैं विच इज़ एक्सपेक्टेड फ्रॉम यू. तो देखिए, डिस्कस द करप्ट प्रैक्टिसेस फॉर द पर्पसेस ऑफ रिप्रेजेंटेशन ऑफ द पीपल एक्ट 1951. ये पहला पार्ट है क्वेश्चन का. यू हैव टू डिफाइन एग्जैक्टली व्हाट डज करप्ट प्रैक्टिसेस मीन्स. करप्ट प्रैक्टिसेस बहुत सारी हो सकती हैं, बट यू हैव टू डिफाइन द करप्ट प्रैक्टिसेस एज फार एज इट्स डेफिनेशन विच इज गिवन इन द रिप्रेजेंटेशंस ऑफ द पीपल्स एक्ट 1951. दूसरा पार्ट क्वेश्चन का, दे हैव आस्क्ड यू टू एनालाइज समथिंग. व्हाट? वेदर द इंक्रीज इन द एसेट्स ऑफ द लेजिस्लेटर. लेजिस्लेटर में मेंबर ऑफ पार्लियामेंट्स भी आ सकते हैं, मेंबर ऑफ लेजिस्लेटिव असेंबलीज भी आ सकते हैं, एंड देयर एसोसिएट्स. एसोसिएट्स कैन बी एनीबडी including the family members, disproportionate to their known sources of income. अब सबकी कुछ ना कुछ known sources of income रहती है, आपकी भी है, मेरी भी है. मान लीजिए आपकी known sources of income में आपकी कमाने की क्षमता साल भर में 1 करोड़ रुपया है और आपके पास प्रॉपर्टी 50 करोड़ की है. या तो आपके पिताजी ने दी होगी, ठीक है, या तो आपको गिफ्ट मिली होगी, या फिर आपने कमाया होगा. इन्हीं चीज़ों में से कुछ होता है. और ना आपके पिताजी ने दिया है, ना आपको गिफ्ट में मिला है, ना किसी प्रकार का इनहेरिटेंस है, ना किसी प्रकार से ट्रांसफ़र हुआ है, बट आपके पास कहीं ना कहीं से आ गया है. आपको पता है सोर्स, बट आप अगर बताएंगे, अगर आप इनकम टैक्स डिपार्टमेंट को बताएंगे तो देयर विल बी एन इशू. व्हाई इशू? बिकॉज दैट विल बी कंसिडर्ड एज डिस्प्रपोर्शनेट इनकम. जितना आप कमा सकते हैं, जितना आप कमा रहे हैं, उससे ज़्यादा इनकम आपके पास है. इसका मतलब कुछ ना कुछ करप्ट प्रैक्टिस इन्वॉल्व्ड है. अब legislators in India, the member of parliament, the member of legislative assembly hold huge amount of influence on the people and huge amount of power also. अगर सीधी पावर नहीं मिली हुई है, अगर मिनिस्टर्स नहीं है, तो भी बहुत सारे सोर्सेज ऐसे होते हैं जहां से कुछ ना कुछ पैसा ये लोग कमा सकते हैं. अब जो नॉर्मल ठीक इनकम, वाइट इनकम अगर आपको हो रही है, दैट इज ओके, बट अगर आपकी इनकम डिस्प्रपोर्शनेट है तो उसको अनड्यू इन्फ्लुएंस कहा जाएगा या नहीं, एंड कॉन्सिक्वेंटली कैन दैट बी कॉल्ड एज अ करप्ट प्रैक्टिस और नॉट. दिस इज द क्वेश्चन. आई होप यू हैव अंडरस्टूड इट. पहला पार्ट, सेकेंड पार्ट, एक एक करके इसको आंसर करने की कोशिश करते हैं. लेट्स सी व्हाट आर करप्ट प्रैक्टिसेस अंडर द रिप्रेजेंटेशन ऑफ पीपल एक्ट. अगर आप रिप्रेजेंटेशन ऑफ पीपल्स एक्ट 1951 को देखेंगे और इसके अंदर सेक्शन 123 को देखेंगे, so you will find the definition of what corrupt practices are. Corrupt practices आपको सेक्शन 123 ऑफ रिप्रेजेंटेशन ऑफ पीपल एक्ट में मिलेगा. सबसे पहली चीज जो जरूरी है जानना, इट इंक्लूड्स ब्राइबरी, ब्राइब देना. और ये सब क्यों हो रहा है, इन सबको करप्ट प्रैक्टिसेस क्यों बोला जा रहा है? क्योंकि ये इलेक्टोरल चॉइसेस को या इलेक्टोरल राइट्स को हैम्पर कर रहे हैं. इलेक्टोरल राइट्स क्या होता है दोस्तों? इलेक्टोरल राइट्स का मतलब होता है अ पर्सन इज एंटाइटल्ड टू वोट. आप भी एंटाइटल्ड टू वोट है, मैं भी एंटाइटल्ड टू वोट हूं, कोई दूसरा आदमी है वो भी एंटाइटल्ड टू वोट है, एंड वी ऑल हैव टू वोट अकॉर्डिंग टू अवर ओन विल. वॉट एवर एस्पिरेशंस वी मे हैव, एंड we think that the particular person, the particular government can fulfill that aspiration, we vote to that person or that party, isn't it? But कोई undue influence हो, किसी भी तरह से, कोई तरह से ब्राइब देके, किसी तरह से एनिमिटी फैला के, किसी तरह से आपको इन्फ्लुएंस करके ऑन द बेसिस ऑफ रिलीजन, रेस, कास्ट, कम्युनिटी अगर वो वोट ले लिया जाए तो क्या? ऑल दोज थिंग्स आर कंसिडर्ड एज करप्ट प्रैक्टिसेस. तो सबसे पहले तो आता है ब्राइबरी. दूसरा इंपॉर्टेंट, अनड्यू इन्फ्लुएंस. Third thing, creating enmity between different communities. Fourth important thing, if polarization of voting happens on the basis of religion, race, caste, community, etc. ये सारी चीजें including one or two more will be considered as corrupt practice under section 123 of the Representations of the People Act. So ये तो हो गया आपका पहला पार्ट आंसर का, आपने करप्ट प्रैक्टिसेस को डिफाइन कर दिया है. इंट्रोडक्शन कैसे लिखना है, आई होप यू नो दैट in introduction you have to be very specific why corrupt practices and the definition of it under the Representation of People Act is important for the free and the fair elections in the country, isn't it? So for the free and fair elections in the country, in order for people to enjoy their electoral rights, corrupt practices needs to be defined. क्योंकि जब तक ये define नहीं होंगी तब तक दोस्तों पकड़ोगे कैसे अगर कोई corrupt practice होती है तो. क्वेश्चन का आप दूसरा पार्ट देखिए, वेदर द इंक्रीज ऑफ द लेजिस्लेटर्स इनकम विच इज वेरी डिस्प्रपोर्शनेट वुड कॉन्स्टिट्यूट अनड्यू इन्फ्लुएंस और नॉट. अगर किसी भी व्यक्ति की इनकम डिस्प्रपोर्शनेटली बढ़ती जा रही है, डिस्प्रपोर्शनेटली मतलब सिंपल शब्दों में बोलूं, अगर ब्लैक इनकम अगर कोई कमा रहा है और वो ब्लैक इनकम अपने इन्फ्लुएंस की वजह से अपनी प्रॉपर्टी को एनरिच करने के लिए कमाया जा रहा है, कैन दैट बी कॉल्ड एज अनड्यू इन्फ्लुएंस. अब आप देखिए एक चीज याद रखना, कोई भी ऑफिशियल, कोई भी पब्लिक सर्वेंट के अंदर आपके लेजिस्लेटर्स भी आते हैं, अगर इनके पास किसी भी प्रकार से डिस्प्रपोर्शनेट इनकम है तो ये किस एक्ट के अंदर बुक होंगे. आप देखिए, प्रिवेंशन ऑफ करप्शन एक्ट, प्रिवेंशन ऑफ करप्शन एक्ट 1988. प्रिवेंशन ऑफ करप्शन एक्ट 1988 का सेक्शन 13 क्या बोलता है कि अगर किसी भी पब्लिक सर्वेंट ने किसी भी प्रकार की एक्टिविटी के द्वारा डिस्प्रपोर्शनेट इनकम जनरेट की है, सो ही विल बी लायबल फॉर पनिशमेंट. दैट इज व्हाट इज सेड अंडर सेक्शन 13 ऑफ द प्रिवेंशन ऑफ करप्शन एक्ट. अब जो क्वेश्चन में आपसे पूछा जा रहा है वो यह पूछा जा रहा है कि अगर किसी लेजिस्लेटर के पास डिस्प्रपोर्शनेट इनकम है तो क्या उसको अनड्यू इन्फ्लुएंस बोला जाएगा या नहीं. बोला जाएगा ओनली इफ दैट डिस्प्रपोर्शनेट इनकम इज यूज्ड टू इन्फ्लुएंस द इलेक्टोरल राइट्स ऑफ द सिटीजंस ऑफ द कंट्री. देन ओनली. अगर किसी व्यक्ति ने डिस्प्रपोर्शनेट इनकम कमा के रखी हुई है बट किसी भी तरह से करप्ट प्रैक्टिसेस में इन्वॉल्व नहीं है, इन्फ्लुएंस करने में वोटर को इन्वॉल्व नहीं है, किसी भी तरह से अगर इलेक्टोरल राइट्स को हैम्पर नहीं कर रहा है, देन द पर्सन विल बी ट्राइड, sent to the jail or will be tried in the court of law under the Prevention of Corruption Act 1988, not under the Representation of the People's Act undue influence. क्योंकि अगर इस केस में आप फंसे तो फिर 6 साल के लिए आप बैन हो जाते हो. 6 साल के लिए आपको किसी भी तरह का चुनाव लड़ने की अनुमति नहीं मिलती है. सो दैट इज व्हाट यूपीएससी इज ट्राइंग टू आस्क. अगर आपको ये प्रोविजंस पता है, अगर आपको पता है कि अगर डिस्प्रपोर्शनेट इनकम होती है, सो हाउ द पर्सन इज गोइंग टू बी ट्राइड एंड टेस्टेड, देन यू विल बी एबल टू आंसर दिस क्वेश्चन. और थोड़ा लॉजिकल भी है. जस्ट बिकॉज द पर्सन हैव डिस्प्रपोर्शनेट इनकम और उसको डायरेक्टली बोल दिया जाए कि दैट प्रैक्टिस विल बी कंसीडर्ड एज अनड्यू इन्फ्लुएंस, दैट्स नॉट द करेक्ट थिंग. द पर्सन विल बी ट्राइड अंडर द प्रिवेंशन ऑफ करप्शन एक्ट, and after that, if that disproportionate income has been used in undue influence, then there is a problem. और undue influence की भी एक छोटी सी डेफिनेशन या एक एक्सप्लेनेशन लिखा हुआ है सेक्शन 123 ऑफ द रिप्रेजेंटेशन ऑफ पीपल एक्ट में. अगर कोई भी व्यक्ति, कोई भी लेजिस्लेटर किसी के भी इलेक्टोरल राइट्स को इन्फ्लुएंस करने की कोशिश करता है, हाउ कि अगर आपने मेरे को वोट नहीं दिया, सो देयर विल बी सोशल एक्सक्लूजन, देयर विल बी एक्सकम्युनिकेशन. व्हाट इज एक्सकम्युनिकेशन? एक्सकम्युनिकेशन सिंपली मींस एक्सपल्जन फ्रॉम द रिलीजन. आपको कम्युनिटी से बाहर कर दिया जाएगा. एक्सक्लूजन फ्रॉम योर कम्युनिटी. देन डिवाइन कर्स, डिवाइन और स्पिरिचुअल कर्स, भाई देश में बहुत से ऐसे लोग हैं हु आर वेरी सुपरस्टिशियस इन नेचर. अगर आपने किसी पर्टिकुलर नेता को वोट नहीं किया, सो देयर इज गोइंग टू बी सम डिवाइन और स्पिरिचुअल कर्स ऑन यू, एंड दैट इज ऑल्सो अ अनड्यू इन्फ्लुएंस which amounts to corrupt practice. कोई भी legislator, if they try to do this, they try to influence the electoral right of the public, the electoral right of the citizen, by telling them that you will come under some kind of divine curse or a spiritual curse. That is also considered as undue influence. Curse so that you can come and vote to me, not to any other person. आप fear generate कर रहे हो, और ये जो इन्फ्लुएंस हो रहा है, नॉट बिकॉज यू आर टेलिंग दैम दैट आई हैव अ मैनिफेस्टो विच टॉक्स अबाउट ग्रेट पॉलिसीज फॉर योर डेवलपमेंट, बट यू आर पुटिंग दैम अंडर फियर एंड यू आर आस्किंग दैम टू वोट फॉर योर सेल्फ. दैट इज कंसिडर्ड एज अनड्यू इन्फ्लुएंस एंड करप्ट प्रैक्टिस. नाउ मूविंग ऑन टू द नेक्स्ट क्वेश्चन. कमेंट ऑन द नीड ऑफ एडमिनिस्ट्रेटिव ट्राइब्यूनल एज कंपेयर टू द कोर्ट सिस्टम. नाउ एडमिनिस्ट्रेटिव ट्राइब्यूनल, आप देखिए फिर इसके दो पार्ट हैं. This is the first part of the question. Comment on the need of administrative tribunal as compared to the court system. Second, assess the impact of the recent tribunal reform through rationalization of the tribunal made in 2021. ये second part है. तो सबसे पहले तो administrative tribunals are there and in general there are court systems. So administrative tribunal क्यों बनाए जाते हैं? सबसे पहले तो there is heavy load on the formal justice system in the country. In order to decrease that load, to bring down the load on the formal Supreme Court, High Court legal system in the country. Second, for effectiveness and efficiency. Effectiveness and efficiency. Why? Because generally the procedures are very informal. इनफॉर्मल प्रोसीजर होने की वजह से लोगों का इन्वॉल्वमेंट भी ज़्यादा होता है और कम समय में, इन वेरी लेस टाइम, अ जजमेंट कैन बी रीच्ड इन द ट्राइब्यूनल. तीसरी बहुत इंपॉर्टेंट चीज, टेक्निकल एक्सपर्टीज. टेक्निकल एक्सपर्टीज. आप जनरली किसी भी ट्राइब्यूनल में जाइए, नेशनल ग्रीन ट्राइब्यूनल हो, इनकम टैक्स अपीलेट ट्राइब्यूनल हो, नेशनल कंपनी लॉ ट्राइब्यूनल हो, आपको हमेशा दिखेगा देयर इज अ जुडिशियल मेंबर एंड देयर इज अ टेक्निकल मेंबर. सो टेक्निकल मेंबर क्यों है? बिकॉज किसी स्पेसिफिक पर्पस के लिए एडमिनिस्ट्रेटिव ट्राइब्यूनल को बनाया गया है और इस स्पेसिफिक पर्पस के लिए एक टेक्निकल मेंबर होना जरूरी. सो दीज आर which the points which shows the need of administrative tribunals as compared to the court system. Now दूसरा लिखा है, एक rationalization exercise हुई थी. Rationalization exercise took place in 2021 and under this rationalization exercise many of the administrative tribunals were merged and were given directly under the high courts. So first thing, why was this exercise done? To bring down the expenses, and second for rationalization. Rationalization, why? Because many of them have similar functions. In order to avoid the similar functions and the too many of number were there, to avoid duplicacy of tribunals, all those which had similar functions were either merged or were sent under directly to the High Court. And that these were the two reasons. But there were several criticism also. Now an act was passed to rationalize the tribunals in order to merge them, in order to send them under the high courts, and this act was passed in 2021. According to this act, there are several criticism which has been given by the public. First thing, is it increasing the load on the formal judiciary or decreasing it? Of course it is increasing it. So the real purpose was forgotten. What was the real purpose? To decrease the load on the formal system. Second, technical expertise which was given is no more available. No technical expertise which is available. Third important thing, इन चीजों को बहुत ध्यान से देखिए. The minimum age was set. Minimum age to be the member or the chairman of the administrative tribunal is 50 years. And the fourth important point, that the member, the tenure for which a member would sit as the chairman, that was reduced from 5 years to 4. Now there were heavy criticism on these 2 points. सबसे पहले तो सुप्रीम कोर्ट का एक जजमेंट है जिसमें सुप्रीम कोर्ट साफ साफ बोल रहे हैं that any person who has been the advocate of the High Court for about 10 years is eligible to become the judge of the Supreme Court, isn't it? And for that reason, and similarly, a person who has been an advocate for a long time, for about 10 years in the High Court, can become the High Court judge also. For a Supreme Court judge, you need to be judge of the High Court for 5 consecutive years. That's one thing. But 10 years of advocacy, 10 years of practice as an advocate is enough. Why you have to put a 50-year mark on it? So this is against the Supreme Court judgment. Second thing, you are reducing the tenure from 5 years to 4 years. Now, more and more executive influence can be seen if the tenures are less. And no person is going to leave their jobs or leave the work, whatever they are doing, to come and serve in the administrative tribunal for a shorter period of time. Because of these 2 important reasons, the reduction in the age, reduction in the tenure was heavily criticized. So these are the points which you can write in this question. These are the impact of the rationalization process in the country, increasing executive control, increasing executive interference in the administrative tribunals. That is what is you have to write in the conclusion here. Now, moving on to the other one. Compare and contrast the President's power to pardon in India and in USA. That is first part of the question. A very good question and an easy one also. You just need to know the the pardoning power of the USA President. You have been reading about the pardoning power of the Indian President from a long time. Are there any limits to it in both the countries, and what are the preemptive pardons? Now, this is the second thing and this is the third part. We are going to see that. Compare and contrast. Now, Article 72 of the Constitution gives the power to the President of the country to pardon, respite, reprieve, commute, reduce any sentence. Now, pardoning and other things can be done by the President on a sentence which has originated as a result of court-martial, is a product of the union law. This is the second thing. And the third important one, it has to be court-martial, a product of union law, and death sentence. Now, death sentence, the pardoning can only be given by the President, not by the governor of the state. So, if the death sentence is given to a person based not on the union law but on the state's law, still the pardoning power lies only to the President, not to the governor. This is important thing you have to understand. Okay. Now, if you see the powers in USA and what happens there, and the pardoning power, of course, let me tell you, the pardoning power of the Indian President, it's not his discretion, but the person has to decide on the aid and advice of the Council of Ministers. At the same time, there is limited judicial review also. There's limited judicial review also. If the pardon is given in a very arbitrary manner, then the judgment of the President can be judicially reviewed by the Supreme Court of the country. Now, comparing this with the USA, comparing this with the pardoning power of the President of USA, if you see in USA what happens, the pardoning power of the USA President is much more wider, I can say, in one aspect. What that aspect is, that he doesn't have to take any advice. So, no advice required. Second thing, pardoning power is done only in the matters of federal law. Only in federal law, not in the state law. Do not forget that United States is a true federal country, and in a true federal country, the states have great autonomy. And when the state have autonomy, they have their own laws, they have their own constitution. They do not allow the president also to interfere. And the pardon is given only in the federal law, not in the state law. Third thing, there is no judicial review of the pardoning power of the president in the United States of America. There have been several examples of pardoning power. Recently, President Joe Biden has given pardon to his own son. He was fixed into something and some wrong he has done, and the pardon was given by Joe Biden to his own son. And maybe that is the reason why UPSC have asked this question. So these are the three important things compared with the President of India and the pardoning power of the President of India and the pardoning power of the USA President, that in USA the President need not to take advice. The second thing, only the pardon can be given on federal laws, and there is no judicial review which can be done of the pardoning power of the President of the USA. Now, what is this preemptive pardon? Preemptive. Is it available in India? The answer is no. This is only available to the President of the United States. Preemptive pardon simply means even before the charges are filed, even before the conviction is done, the person has been given pardon by the President. So, the pardoning power of the President of USA is quite wide compared to the Indian President. Preemptive pardon is not a reality in India, but a very much reality in the United States. There are examples also. President Ford, for example, has given this preemptive pardon to Richard Nixon. This was one example. It happened back in the 1960s and 70s. It's a very, very important example here. Moving on. This is the next question. Question number 4. Discuss the nature of Jammu Kashmir Legislative Assembly after Jammu and Kashmir Reorganization Act. And second part, briefly discuss the powers and functions of the Assembly of the Union Territory of Jammu and Kashmir. Now you know, after the Reorganization Act of 2019, the special status which was given to the state of Jammu and Kashmir under Article 370 was taken away. And the state of Jammu and Kashmir was divided into two parts. One, the Union Territory of Jammu and Kashmir. Second, the Union Territory of Ladakh. Okay. Now, the Union Territory of Jammu and Kashmir, if you see this, it is with Legislative Assembly, and this is without Legislative Assembly. The Legislative Assembly of Jammu and Kashmir, the Union Territory of Jammu and Kashmir, works in accordance with Article 239A of the Indian Constitution. Similarly, the Puducherry Union Territory also works under Article 239A of the Indian Constitution. Now, if you look at the power of the Union Territory of Jammu and Kashmir, the Union Territory of Jammu and Kashmir and its Legislative Assembly can do everything which comes under its power, and it can legislate on the state list. It can legislate on the concurrent list. ये उसी तरह से जैसे दूसरे स्टेट्स की लेजिस्लेटिव असेंबली या यूनियन टेरिटरी की लेजिस्लेटिव असेंबली अपना काम कर सकती है. इन द सिमिलर फैशन द लेजिस्लेटिव असेंबली ऑफ द यूनियन टेरिटरी ऑफ जम्मू एंड कश्मीर कैन वर्क. There are two exceptions which are given. If you see entry number 1 and entry number 2, entry number 1 and entry number 2, which is public order and police. And this entry number 1 and entry number 2 is of the state list. क्या बोलता है? Entry 1 बोलता है public order, entry 2 बोलता है police. इन दोनों मुद्दों पर the legislative assembly of the Union Territory of Jammu and Kashmir has no right to make law. So this is a bit of a complex situation here compared to other states. अगर आप दिल्ली से इसको कंपेयर करें, so there are 3 things on which Delhi State Legislative Assembly cannot make law upon. First is the public order, second is police, and third is land. Land के ऊपर law बनाना is allowed for the Legislative Assembly of Jammu and Kashmir. It plays all the normal functions compared to the other legislative assemblies of different union territories and the states. So this is it. This is what you have to write in this question. If you know the broader perspective, now if you see a bit about the nature of the Legislative Assembly after the abrogation of Article 370, the numbers of the elected numbers have been increased to 90, and 24 these people are from these seats which are vacant are from Pakistan occupied Kashmir. So in total in the Legislative Assembly of Jammu and Kashmir there are 104 vacancies or seats, you know, which needs to be filled after the election. 24 generally remains vacant. Why? Because the elections in POK are not held, unfortunately, now. Maybe that may happen in future. And 90, when India is going to control this portion of Kashmir, and the 90 Legislative Assembly seats have to be filled by election. Out of these, if you see, 7 have been reserved for scheduled caste, 9 have been reserved for scheduled tribe. There are 3 members who are nominated. Now these nominated member can be a displaced person from Pakistan occupied Kashmir or can be a migrant. And out of these 3, out of these 2 migrant people, 1 has to be a woman. So this is little detail which you must know about the nature. It is very much representative in nature. It is giving representation to the scheduled caste, to the scheduled tribes, to women, and there are nominations also. And it is doing perfectly good work as compared to any other legislative assembly of the union territories. Only 2 exceptions. One is the public order and other is police. On these 2 items, the union territory of Jammu and Kashmir does not legislate. Rest all things are okay. Now, when it comes to the financial power, any money bill which needs to be introduced in the legislative assembly of the union territory of Jammu and Kashmir must get the prior recommendation of the Lieutenant Governor. Lieutenant Governor plays a very, very important role in a union territory. The same person is known as Governor, but the same person, when the Governor of a state, the executive head of the state, but the same person in the union territory is known as the Lieutenant Governor. And the Lieutenant Governor gives the prior recommendation to the financial or the money bills. So an overarching power somewhere, a discretion also lies in the hand of the Lieutenant Governor for, you know, appointing a chief minister when there is a hung assembly or reservation of a bill for the consideration of the president. All these things are there, and the prior recommendation when it comes to the money bill. Now, when the prior recommendation is taken from the Lieutenant Governor, you can very well see that the Lieutenant Governor is directly appointed by the center, and he is also the agent or a representative of the central government, and hence the interference of the central government is a bit more. That is a very important thing which you must understand, that not all the time the Lieutenant Governor of the Assembly of Jammu and Kashmir or the state or the Union Territory of Jammu and Kashmir works on the aid and advice of Council of Ministers. So in a nutshell, this is the whole answer. Moving on. Now comes the Attorney General of India. Attorney General of India plays a crucial role in guiding the legal framework of the union government and ensuring sound governance through legal counsel. Discuss his responsibilities. This is the first thing, his rights and the limitation. Now, if you see the Attorney General, under Article 76 of the Indian Constitution, the President has to appoint an Attorney General. What will be the responsibility of Attorney General? The Attorney General is going to give legal advice to the government of India for whatever advice which the President asks of, the Attorney General has to give all the legal advice. Then the Attorney General fights the cases on behalf of the Government of India in different courts. He appears in the Supreme Court, in the High Court, and if necessary in other courts also. Then comes the third one. Any other work of legal nature can be assigned to the Attorney General by the President of the country. So these are the responsibilities. He majorly gives the legal advice, and Attorney General is the person who has the eligibility to become the judge of Supreme Court. That simply means must be a judge of the Supreme Court, a judge of the High Court for 5 years, an advocate of the High Court for 10 years, or an eminent jurist in the eyes of the President of the country. So the person must be eligible to be the Supreme Court judge. So this person gives the advice, appears on the behalf of Government of India, and yes, the appearance can also be there now. This is the right which he has. What are the rights? He has the right to appear not only in courts but also in the sessions of Parliament. Session of Parliament. It can be Lok Sabha, it can be Rajya Sabha. Also in the joint session. It can also be there in the committees. There are ad hoc committees, standing committees of the Parliament, and the Attorney General has all the rights to attend the meetings of the committee. The only thing, the only limitation which is there is that the person cannot vote. Attorney General cannot vote when it comes to voting in the houses of the Parliament, the Lok Sabha, the Rajya Sabha, or the voting in the committee. Can be standing committee, can be ad hoc committee, different committees of the Parliament. Now there are other limitations also. Other limitations such as he does not have a tenure, fixed tenure. There is no fixed tenure. Attorney General remains in the office till the pleasure of the President. And usually what happens is when the government is changed, Attorney General submits his resignation to the President. So these are several limitations. He cannot go and vote. He doesn't have a fixed tenure, always works on the pleasure of the President. These are few limitations, but it's a very, very important post. He is the one who represents the government in the court. He is the one who advises the government on the constitutionality of laws, on any legal matter which can arise. And Attorney General plays a very, very important role. So I hope we have seen the responsibilities, rights and limitations of the Attorney General. Moving forward, this is another question. This line has been taken from the judgment of the Supreme Court. What it says: constitutional morality is the fulcrum which acts as an essential check. Constitutional morality is acting as a check upon what? High functionaries and citizens alike. So constitutional morality has to be a check. Constitutional morality is nothing more than the values which are enshrined in the Indian Constitution. The values such as liberty, equality, fraternity, values such as rule of law, secularism, brotherhood, all these things are very important. Even the accountability factor, accountability as a word is not being used. Morality as a word is not being used in the Indian Constitution, but it is reflected. It is reflected in the provisions. So any kind of value which is enshrined. Justice, social justice, it's a value. Liberty, it's a value. If we respect the liberty of the people, then you follow that value, isn't it? And the constitutional morality, now what is asked here? In view of the observation of the Supreme Court, explain the concept of constitutional morality. So this is the first thing. The constitutional morality is nothing but the values which are enshrined in the Constitution. Values such as liberty, equality, fraternity, secularism, rule of law, all these things. They're very important for the functioning of the society, and they are majorly reflected, if you see, in the preamble, in the fundamental rights, in the fundamental duties, in the directive principles of state policies. Fundamental rights and fundamental duties are usually for the citizens of the country, for the individuals. There are individual rights, there are community rights. Along with it, there are duties which needs to be followed by a citizen. These directive principles are nothing but the directives which has been given to the government while making the law or while executing the law. And it does have the element of constitutional morality. And let me tell you one thing, there is a overlap also. If you see constitutional morality and basic structure, there is an overlap between these two things. Many of the things which are considered as constitutional morality, such as liberty, equality, fraternity, secularism, is also the basic structure of the constitution, isn't it? Moving on to the second part of its application to ensure balance between judicial independence and accountability in the country. Now, it's very important for us to understand that judiciary has to be independent. Judicial independence. And judicial independence has been seen in several facets, like the judges' cases. In judges' cases, there are 1, 2, 3, 4 judges' case. Last one was when the Supreme Court has declared National Judicial Appointment Commission as non-constitutional or infringing upon the judicial independence of the judiciary and against the basic structure of the constitution. So this is one way where the judicial independence is maintained. Second comes the salary and allowances of the judges, which are charged upon the consolidated fund of India, cannot be voted against their interests by the parliament. So less and less intrusion of the parliament in the affairs of the judiciary. See this. The judges' cases, they have, in one or the other way, has created the idea of collegium system for the appointment of judges. So the appointment of judges are done by the judges, and that is the peak of independence which you can have. Then comes the salary and the allowances. Then contempt of court power. This is one way in which the independence of the judiciary can be seen. Then the conduct of the judges are not to be discussed inside the parliament. Again, judicial independence, one of the facets. Now, when the judges do have all these independence factor with them, when the judiciary is independent, that judicial independence must not be used in order to cover up for accountability. There has to be a balance between judicial independence, which is very much required, and judicial accountability. Judicial accountability is very important, because if there is no accountability, there cannot be rule of law. If there is no accountability, there will be lack of separation of power. And both these things, if you see, are under constitutional morality and also the basic structure of the Indian Constitution. There is an important thing called constitutionalism, limited government, the rule of the law, not the rule of the man. That is the reason why constitutional morality creates a balance between judicial independence on one hand and judicial accountability on the other hand. There have to be judicial independence, of course, but it should not cover up for judicial accountability. Judicial accountability also has to be seen, and it is reflected through rule of law, separation of power, and hence, this judicial overreach or judicial activism should not be so much that it somehow infringes upon the roles of executive and legislature. Along with it, the recent corruption cases which are surfacing in judiciary also calls for some kind of judicial accountability. There is an in-house procedure, and doubts have been raised on that in-house procedure in order to keep the judges accountable for their conduct. So this is what the answer is all about. There has to be a balance between judicial independence and judicial accountability, and the constitutional morality is the basis of attaining that balance. That is what was asked in the question. and also you have defined the constitutional morality. Moving on to the other question, question number 12. Indian Constitution has conferred the amending power on the ordinary legislative institutions with a few procedural hurdles. So there are few procedural hurdles, and the amendment is done by the Parliament, the two houses of the Parliament. In view of this statement, examine the procedural and substantive limitation on the amending power of the Parliament to change the Constitution. Now, the amending power of the Parliament simply comes from Article 368 of the Constitution. Now, there are several procedural and there are several substantive limitations on the power of the Parliament. First thing, if you see the procedural one, there is a need of special majority. Now, to gain the special majority is not an easy thing. Special majority needs that there shall be a majority of the total membership of the House plus 2/3 of present and voting. Now, recently 130th Constitutional Amendment Act was introduced and government wanted it to be passed. But if you see the 2/3 majority of the Parliament, 363 members, the government does not have 363 members. So, don't you think it's a procedural check on the amending power? Of course it is. So, this is the one. Second thing, if you touch any federal character of the Constitution of India, any federal character such as some changes with goods and service tax, changing the powers of the Supreme Court and the High Court, changing the powers and the composition of the Council of State, which is also known as Rajya Sabha. You don't only have to pass the amendment by the special majority, but you also need half of the states to pass this particular amendment with simple majority. So this is another procedural limitation on the amending power of the Constitution, the amending power of the Parliament. So these are the two important things. The third thing, you need the assent of the President of the country. Now the President can do several things when an amendment bill comes to him. Okay, can send it back, of course, but somehow he has to give the assent to that particular bill. You know, he has to give the assent, but there is a check. He can keep that bill pending for a long period of time, but some check is there. Cannot send it back to the assembly, but some check is there. Now, if you see the substantial thing, substantial limitation, what can this be? Parliament can amend anything, but not the basic structure of the Constitution. Parliament can amend, but must abide by the constitutional morality. It must, in every manner, should respect the fundamental rights of citizens. It must not be curtailed. So these are the substantial limitations. Should follow constitutionalism. Must not have any overriding power over other organs of the state, such as judiciary. So following of constitutionalism. This is also very important. So these points fulfills the demand of the question. So there is this legislative, institutions. They do have procedural hurdles. They do have substantial hurdles. These are the procedural hurdles and these are the substantial hurdles. Moving on. Discuss the evolution of collegium system in India. Now, collegium system, as we have already discussed here, it's not there in the Constitution of India, but was evolved by different judgments of the Supreme Court over a period of long time. So we are going to see how it happened. Critically examine the advantages and disadvantages of the system of appointment of judges of the Supreme Court of India and that of the Supreme Court of the USA. दो question आ गए हैं comparison पे. One was the pardoning power of the President of India versus the pardoning power of the President of the USA, and second is the appointment of judges in India and appointment of judges in the USA. We are going to see both. Now, if you see the collegium system in India, something is called as the first judges cases. Now, this happened in 1981, long back. So how a judge is appointed in India? The judge is appointed by the president of the country. Judge is appointed by the president of India. He needed to take consultation. Consultation from the Chief Justice of India. So consultation is taken by the president from the Chief Justice of India, and then the president can appoint the judge. Now, the consultation which is given by the Chief Justice of India is not binding. It's not binding on the president. We are talking about 1981 and that period, or initially what used to happen after the commencement of the constitution. Now it does not happen because the things have changed over a period of time. But earlier this consultation was not binding on the president, and president of course works on the aid and advice of the Council of Ministers and could appoint anybody of his liking. He only needs to consult the Chief Justice of India. But then several things have happened, changes have happened over a period of time, and then comes the second judge's case. This happened in 1993. The word consultation was seen as concurrence. The word consultation was seen as concurrence. That simply means that whatever consultation was given by the Chief Justice of India to the president is binding on the president. President has to concur with the advice of the Chief Justice of India. So first, there was a primacy in the appointment of judges by the primacy to the decision made by the president. Now the primacy is shifted. Determinative factor is the Chief Justice of India. Okay, and the Chief Justice of India along with few judges. Now initially in the second judge's case, it was Chief Justice of India plus two senior most judges. They are going to form the collegium, and this collegium is going to be consulted by the president, and the advice which is given by this collegium will be binding on the president. So here what is happening is, in the appointment of the judges of the Supreme Courts are playing the major role or the total role. The government has no say. The President, Council of Ministers has no say in it. Now, moving on to the third judges' cases. That happened in 1998. The collegium was increased from 3 judges to 5 judges. Chief Justice of India plus 4 senior most judges of the Supreme Court. This was the collegium. And if any 2 of the judges out of these 5 were adverse, were against any particular candidate, that person shall not be sent as an advice to the president of the country. Still, the appointment is done by the president only. But the consultation is concurrence, means the advice which is given to the president is binding. This is important, and this thing has evolved over a period of time from 1981 to 1993 to 1998. And the fourth judge's cases. Now the fourth judge's case was of 2015 National Judicial Appointment Commission, where the National Judicial Appointment Commission was constituted by the government for the appointment of the judges, but this was declared as null and void, unconstitutional, infringing upon the independence of the judiciary by the Supreme Court. So the primacy is always there with the Supreme Court. Now compare this process with what happens in the United States of America. That is what is asked in the question. This appointment process and their disadvantages. What happens in India? What is the disadvantage in India? That judges are appointing judges. So nepotism can be seen. There is lack of transparency and accountability in the whole system. The involvement of the parliament or executive is not there. So these are the disadvantages. This doesn't happen in any other major country of the world. But if you see what is the process in the United States of America, president of the USA, he recommends the name. He recommends the name to the Senate. Senate means the upper house of the parliament. Now, Senate takes over that name, broods over that name, sends it to the committees, There is a voting in a committee. Then finally it comes and there is a voting in the Senate. And whichever person wins, his or her name is sent to the President of the United States for appointment. So there is a heavy involvement of Senate, and that's why the disadvantage is that there is a heavy political involvement in appointment of judges. The same process is followed in federal judges, district judges, everywhere in the United States. But it is heavily politically motivated appointment process. So that is the answer of the question here. Now moving on. Examine the evolving pattern of center-state financial relations in the context of planned development in the country. Now there has been planned development in the country from a very long time. If you see the planned development of the country, it has started with the 5-year plans after the commencement of the constitution in 1950 also. First 5-year plan, second 5-year, third 5-year plan, and so on and so forth. How far have the recent reform impacted the fiscal federalism in India? So there used to be something called, if you see in this period, there used to be something called Planning Commission, and along with it the Finance Commission. The role of the Finance Commission was to divide the proceed of the tax. How much taxes should the state get? The 13th Finance Commission told that it must be 32%, and then it was increased. Now the Planning Commission was there to plan the economy, and the Planning Commission played a very important role in the 5-year plans. After 2014, there was a huge change in the planning process in the country. In this period of time, there majorly whatever grants which were given, the loans which were given to the state governments were tied. They were tied to some kind of scheme, or maybe for a centrally sponsored scheme. But after 2014, what has happened? The Planning Commission was replaced by Niti Aayog. The Finance Commission still works, and the recommendation of the Finance Commission, the 14th Finance Commission, to devolve 42% of the total tax, and most of it is untied. Here it used to be tied. That simply means the state will only spend that amount of money for a particular purpose. But when the revenue is untied, that simply means the state can spend that amount of money in whichever way it likes. So what is happening? What change has come? If you see, when the state gets untied revenue, they can spend in whichever way they like, and hence the democracy is flourishing even more. If you see the state level, they are becoming more financially free in order to spend, make their plans and do it. And they are always considered as very much close to the public, more close than the central government. And hence they need that some kind of decentralization, fiscal decentralization is very much important. The state must take their own decisions when it comes to planning, when it comes to spending the money. And of course, after this 2014, majority of the states are also devolving some amount of funds to the basic grassroots level panchayats and municipalities. This is also one of the changes which is taking place when it comes to cooperative federalism in the country. And what happened in 2017? 2017 comes the GST Council. Now the GST Council is very important council when it comes to the cooperative federalism in the country, because the voting pattern which is given in the GST Council involves everybody, involves the state, involves the center. There is a criticism that the northern state, which has more and more population, is given more votes, more value of the votes when it comes to the voting pattern in the GST Council, and the southern state has not been given that much. Again, a penalization for implementation of the population policies in the country. Then the second criticism, important criticism, was that the central government has not paid the dues which have to be given to the state government after the implementation of the GST. But in total, if you see the planned development in India, and this planned development, when you see, it can be in the sector of infrastructure, can be health, can be education. Now education is in the concurrent list, health is in the state list, public order, police, everything. They are moving forward. New technologies have entered the health sector, the education sector, the public orders, and the police. And this has happened because untied revenue has been provided to the state government by the central government. If the revenue is very much tied, there is a problem. Because if the revenue is tied, it is tied to a particular centrally sponsored scheme, and it can only be spent in that particular direction, in no other direction. Now states are in a better position to spend the money according to their own needs. But that facility, that freedom needs to be given, and over a period of time we have seen that that kind of freedom is given to the state to spend their own money in the way they like. And it is very much important also to decentralize the financial resources in the country. So this is the answer, and it has have a great impact, positive impact. There are negative impacts also, which we have discussed, that the GST Council, some dues which needed to be paid, some compensation which needed to be paid, was not paid on time. And of course the northern state gets more voting power compared to the southern state. This is one of the criticism. But overall, if you see, the impact is great. Fiscal federalism is increasing and improving. There is more and more cooperative federalism in the country because of the introduction of GST, because of the finance commission, which comes after every 5 years and has recommended to devolve huge amount of money, untied money, to the states. In the recommendation of the 15th Finance Commission, this 42% has been reduced to 41%, just because Jammu and Kashmir is no more a state but a union territory. So this is it, friends. This is what our discussion was all about. There were 9 questions of Indian polity in the mains paper of 2025. Thank you very much for listening to me. Have a nice day and Jai Hind.